Testing 1 2. Testing 1 2.
Ladies and gentlemen, I want to, let's see, 1, 2, 3, 4, 5, 6. We need 7 to conduct this meeting because it goes from the committees to budget and finance. And so if we don't have enough quorum, we need the majority of, have them be quiet out there, or close the doors. We need the majority here in order for us to conduct business. The issue, and most of you may know or may not know, but the issue is here is that we are have two different set of meetings going on. And I want the public to understand that the quorum court members can have meetings. It's legal for them to call a meeting. It says the judge or the majority of the quorum court members can call meetings. The issue is that a lot of those meetings hadn't met certain criteria, statutory criteria. And so you've heard quorum court members say that they cannot participate in the meetings called by the county judge, where the agenda comes out of this office. They're acting as the fact that the agendas come out of the county clerk's office. And even if they did, or their procedural rules that they think they passed were legal, those agendas that come out of there will still have to meet with my approval. The other issue is that, ladies and gentlemen, this is not happening in any other county in the state. We are the laughing stock of this whole state. We got individuals who, because of litigation, the county attorney had tried to advise that the procedural rules that they were trying to put in place, many of those rules tried to usurp the authority of the county judge. Nothing wrong with the quorum court getting procedural rules together. But when they infringe upon any other constitutional officer's right, it violates separation of powers. It can't be but one county judge. One county judge. Oh, now we have another one, so we may be able to. 1, 2, 3, 4, 5, 6, 7. We can have the meeting of the committees, but as far as the budget and finance, we need the quorum court meeting. We'd have to have 9. No, I mean, we already have the chairs. I let the chairs. Yeah. Okay, ladies and gentlemen, since we do have 7 now, but I would like, before we get started, I would like to finish what I was saying. The premise on the fact that they feel that a procedural ordinance was passed. I'm gonna, before we get started, if you allow me, I'm gonna show you a little video that will entail that a procedural ordinance has not been passed. What you'll see in this video, and I'll explain as it is shown, that a amendment was made from an 18-page document down to a 4 or 5-page document. But that document itself, as a procedural ordinance, was never voted on, was never read by title. Several violations of the law occurred when this particular meeting went on, and it was deemed an illegal meeting. But I want to show you that a procedural ordinance has not been passed. So I want you to start this video. In absence of the county judge, Stop it for a second, stop it for a second. In absence of the county judge, quorum court members can have a meeting. You'll see that I was present at this meeting, and they continued this meeting after it was adjourned. Whether they felt like it was adjourned correctly or not, they continued a meeting immediately after a meeting, to say the least, that violated FOIA. So we're going to continue, and you'll see, listen, I want you to listen very carefully, and if you have any questions, then I will explain it to you. Okay, go ahead.
I'll start from the beginning.
County Court for the election of 2023.
With this ordinance that's on here, we've already been working, this has been vetted by the attorney. Rules and procedure is actually a working document, so if there are any problems with the current amendment that I'm about to make, it can be made at a future time. But with that being said, I would like to make a motion to amend this ordinance with the amended with the ordinance 782, which you all have been emailed, the 4-page document that was originally drafted by the Judicial Committee back in February, but it has been shortened down to 4 pages at the discretion of the county attorney. So at this time, if we can get a second, we can amend to this one that has been emailed out to justices, and in case you guys need a hard copy, we'll get it.
Justice Johnson there, but I think you had Justice Johnson was the chair vote.
And in case they're confused, this is the one that's actually been vetted by the attorney, and it doesn't have to be on the agenda. It is an amendment, so we're amending the current one to read just the one that's on that.
You made your motion?
Yes.
Do we have a second?
Second.
We have a motion and a second to substitute the document that's been prepared by the Judicial Committee.
Or careful, not substitute, make it read as this one reads, 782, which we received in the email. To make it read as this one. And we have that. Did we get a second?
This is the edited version.
Correct.
Of 781,
right.
The one that has now been reduced from 19 pages to 4 pages.
Correct.
So we want to make that clear.
Okay.
That it has been edited, it has been redefined. The difficulties that were in it initially, many of them have been walked through. There may be some still typographical errors, but they can be straightened out, like an S or, like a comma or something like that. But the essence should be where we are.
Madam Justice, are you speaking to the motion or?
I'm speaking for clarification so that I can have those who are listening and those who are here in the room to understand what is happening.
This is the most updated version as of meeting 4 o'clock with Attorney Wednesday.
Okay. So we have a motion, we have a second, we have explanation. Are there any additional questions about the motion on the floor? If there's no additional questions, all those in favor of the motion signify by saying aye. Aye. Let's take a voice vote, please. I mean a hand vote, please. Call names.
Adams.
Yes.
Agee. Bird. Curl. Dumas.
Yes.
Franklin.
Yes.
Gaddy.
Yes.
Hardin. Holcomb. Jackson. Johnson. Patricia Johnson. Reginald Johnson.
Yes.
Margaret Williams.
Yes.
Opposed, same sign. Seeing that there are none, appears that the ayes have it.
Okay. So, ladies and gentlemen, what you just saw was a motion made to amend the procedural ordinance that they put in place, or that they were trying to put in place. A motion to amend from 19 pages down to 4 pages. Even if they had passed a procedural ordinance, they never read the ordinance by title. They never read it by title. They didn't have the 2/3 votes or 9 quorum court members to suspend the rules, so that they wouldn't have to read it 3 times. They didn't read it 3 times. They never voted on the 4-page document itself. So a procedural ordinance has never been passed. The only thing they did was voted to amend from 19 pages down to 4 pages. The county attorney has viewed this. It hadn't been passed, hadn't been read, didn't garner the 2/3 votes to suspend the rules. That's not a procedural ordinance in place. A lawsuit was filed, an amended lawsuit, explaining to the justices that they have not passed the procedural rules and urged them to pass a procedural rule, and hadn't been done. As you can see, nothing is legal unless it is read, and you have to read it by title so that the public will know what we're gathering here to do. And from watching that, I guarantee you know what we even passed. It did not happen. So we have no procedural rules in place. It's not there. But yet, we have several justices acting upon the fact that they think that they have passed a procedural rule. And even with that, there's not 2 quorum courts. There's 1 county judge, and there's 13 justices. Justices are responsible for appropriating monies. They're not responsible for telling the treasurer how to do her job. They're not responsible for telling the sheriff how to do his job. They're not responsible for telling the county judge how to do his job. The county judge is responsible for the expenditures of the budget. Every dime we have coming in is either tax money, grant money that comes into this county. It is the people's money. So that when you have bills that have to be paid, whether you think or like the official that's in office who has put it in place or not, you still have a responsibility to take care of this county. You have a responsibility. And you appropriate money for one elected official and not appropriate it for the other, you have that right as the quorum court members. You're the purse holders. But at the expense of ruining this county, bills being delinquent, stopping operations, that's wrong. The people elected us to do our jobs, period. To do our jobs. There's nothing, I've said this many times, there's nothing in the Constitution say that any elected official have to like one another. But in the grand scheme of things of doing their job, government is a well-oiled machine that you don't have to be friends, you don't have to be family, but if you're doing your job, you're going to do the people's business. That's going to happen. But we have delinquent bills. The road department has delinquent bills. The veterans building has, the veterans have delinquent bills. We have delinquent line items in the negative. I have come to this quorum court month after month after month asking for those to be the appropriations. And the appropriation is only the permission to use money that's already there. And that hasn't happened. And for that, I have vendors out in the audience. How many vendors do I have in the audience? I got 3 or 4 vendors out in the audience that have not been paid. have not been paid. Interest is occurring. Late fees is occurring. And that doesn't make sense. This money is the people's money. I can promise you that if the treasurer tells me that we don't have the money to pay something, she'll tell you, I'll say it can't be done. We wanted to do bonuses for the employees. Now, many of the justices say that they've passed this, they passed. We set a meeting, we have it, and they said, our attorneys say that we can't participate in your meeting. The meeting that you elected them to participate, whether they like me or not. They have a responsibility. So they don't participate. So they have their separate meeting, a separate meeting where they violate the statute. It doesn't meet the statutory requirements for the calling of that meeting, but yet they have it anyway. So there's times I've had to veto. The thing is that we have items on this agenda that has to be taken care of. Have to be taken care of. If we go into default, only the essentials will be taken care of, and that's the jails, detention, MECA. Those are essentials. We'll have to take care of those. But everything else is going to be shut down. Government will be shut down. Employees won't get paid. And I don't know about you, but I value our employees. We had a justice say that the bonuses that we were asking for was too excessive. How dare a justice of the peace who do not work, who do not know our employees, put a value on a request that was asked for each elected official. This request was asked because many times elected officials ask me, can we do bonuses? I say, if the money is there, we'll do it. I don't make the decision to give them bonuses. I only provide the avenue if we can. If the treasurer would have told me, Judge, we don't have the money to do it, I'd say, well, no bonuses this year. But I ask each elected official, if you can find it within your budget to do it, then we'll do bonuses. And they did that. It was only 2 elected officials that didn't send their stuff to my office. Only 2. But everybody else sent where the money would come from and where it would be transferred to do these bonuses. The bonuses range from $1,500 to $3,600. There was a criteria sent out. Each elected official had to do evaluations to meet that criteria. I didn't say how much they would get. I gave a range. So and then they had years of service along with performance in order for them to get the money. But because they didn't want it seemingly to come from my office, they decided to have a separate meeting. Again, meeting didn't meet statutory requirements. And they say it's passed. But the funny thing is nobody's signed anything. The county clerk's office hadn't signed anything. The county attorney hadn't signed anything. I haven't signed anything. And in every instance, when they say they've passed something, hadn't come to my office, so I don't know what they've passed. I don't know what they've done. But I'm here to tell you tonight that we're going to persevere through this. We're going to get through this. I'm not going anywhere. I'm on a 4-year term. These justices of the peace are 2-year terms. It may take us a minute to get it done, but we're going to get it done. All the while, I want you to understand that if we don't pass a budget, and we have worked hard to get this budget passed, we meet the 90%, and all we need to do is come together and get this done. But yet you see those empty seats. Justices are holding out because they don't want to come to a meeting. Now, they expect to get paid. They're going to come to this meeting, a meeting that I call, because they want to get paid. They want to get paid. But yet they come to the meeting and say, I'm not participating. But you show up and you want to get paid. Every one of them, I dare say, I don't know what each of them do, but they got jobs. They expect to come here and get paid. You vendors expect to perform a service to Jefferson County. You expect to get paid. You have insurances. You have employees. You have needs that you have to meet. They get paid. But they don't want to appropriate the money to pay you. It's wrong. And we, as grown individuals, ought to be able to put differences aside for the people. We ought to be able to put differences aside for the people. And I'm telling you, there are some, I'm surprised at. I am surprised. But we should not let differences halt county business. We shouldn't. Now, we can go through this agenda. We can go through the committee stuff, but we don't have enough people to handle county business to get it through budget and finance. So really, I'd be wasting your time and my time to try to continue, and we don't have enough people here to do it. The meeting was called. I think the press got the email from my legislative clerk, who is located in the county judge's office, where the agenda comes from. And let's talk this. Even if they had passed their procedural ordinance, even in their 4-page document, they admit that the legislative clerk rests in the county judge's office. There has not been an appropriation to reduce my budget to move him to the county clerk's office or to add to the county clerk's office. The legislative clerk is in the county judge's office, where the agendas have come from the last 30 years. The last 30 years. Now business is halted because you don't like who's sitting in the seat. But 4 years prior to, 4 years, we accomplished so much. And whether certain individuals like to hear it or not, we move forward. You had a meeting here the other night. 24 hours notice was given. They met up in the circuit judge's office, circuit judge's courtroom with a 24-hour notice. And the statute clearly says you must give a 2-day calendar notice. And that wasn't done. Then after that, this meeting was called last Tuesday, or sent to the press last Tuesday, over a week's notice. What happens? They decide to have a meeting the same time as this meeting. Now, what kind of game is that to play? We got a tax rate that needs to be passed. The county attorney, I'm gonna let him tell you how important it is. Terry, if you would.
The levy of taxes for the operation of the county for next year must be approved at the December meeting. That's tonight. If it's not approved at the December meeting, it cannot be approved at all, and therefore the county will have no levying authority. It won't be able to send out tax bills. It won't be able to collect taxes. I sent that by email as a cautionary email this afternoon to all the justices. Those of you who saw your email saw it. It's just simply an alert. You all have got to pass the levy for next year's taxes. The budget for next year also has to be passed by December 31. That doesn't have to be addressed tonight necessarily, but I don't understand taking the position that I'm not going to participate because that somehow might jeopardize some litigation that may be pending, or advice of counsel that's doesn't even live in Jefferson County. I implore you all to contact those that are not here, because we do have to have 9 to approve the levy. Implore them to show up and at least vote on that issue. Approve the levy so that the county will have money. If it's not approved at this meeting, it can't be brought up at a special meeting or a subsequent meeting. It may be possible to to continue part of this meeting, but unless we're going to change the posture of the court, we all come together to approve that county levy. It doesn't do any good. I'm really disappointed to see that there are people who are not here on so important an issue that they are willing to forfeit the county's authority to levy and collection of taxes on some legal or political point they're trying to lie on. I can't explain how important it is to get this done tonight, and if they're not here to even talk about it, I don't know how we move forward. So if you all have any power over the missing members, tell them to at least show up so that we can consider these things. We can always work around these legal positions so that it doesn't cause any bias in any future litigation or anything. But if the levy's not passed tonight, it doesn't matter what we do. We won't have any money as of December 31. We won't have the authority to collect it.
Thank you, Attorney Nguyen. So, ladies and gentlemen, I have offered conference. We have, talking about the litigation, we have offered to mediate with the opposing attorney. That has not happened. We're still working on that. But we need to come together to handle county business, period. And I know it has made some of us sick about it. I've had conversations with others. And what are we going to do? What are we going to do? This is so important. But we have to really look at, because of personal differences, we're willing to sacrifice this county, sacrifice its employees, sacrifice government. Whether right or wrong, whether they feel like I'm right, I feel like, or they feel like I'm wrong, I feel like they're wrong, that's not even the issue right now. The issue is handling county business. So I'm going to not adjourn, I'm going to postpone.
We haven't even adjourned yet.
Yeah, we have, yeah.
My suggestion might be, I'm assuming since some of the other just as we're calling their own meeting, they may be nearby. I would propose to the court that we take a 15-minute recess, have you all that have any authority over them, ask them to at least show up and explain to you, the people, and the rest of the court, why it is they won't participate in approving the levy tonight. I don't understand why they're not willing to show up and do that. And then ask that the meeting be reconvened at 6:15 or something.
Okay. We'll take a 10-minute recess and reconvene in 10 minutes.
She got dressed. She got dressed again.
Don't convene no more. It's a, or if you do convene it, it's suspended.
Make troubles.
Yeah. Ladies and gentlemen, you can relay this out to the hallway. We're going to postpone this meeting until 5:30 next Monday, which will be December the 18th. This meeting is postponed until 5:30, 12/18. Okay?